Yes.
May I please, Your Lordship? Lordship, sorry for the indulgence, Lordship. I would like to mention item number 21 and 22 of the hearing list, Lordship.
Item number
21 and 22.
21 and 22.
Yes, Lordship. Lordship, if this matter can be upgraded to first item hearing, Lordship, because learned AG is appearing in this case, Lordship.
All right.
I've taken the consent of the other participants.
We'll after the admission matters, we'll take it for hearing.
Lordship.
Or you want it even earlier?
Lordship.
Mr. AG, would you want item number 21 and 22 to be taken up as the first case after the admission matter? All right.
Obliged, Lordship.
All right. You have informed the other side?
Yes, Lordship. I've already
All right.
So, Lordship.
Yes.
Lordship, I beg to mention item 16, Your Lordship. Can it be taken up tomorrow, Your Lordship?
Item number 16.
Yes, tomorrow, Your Lordship. Today I have some difficulty.
All right. Tomorrow.
Much
Pass over. Let this matter come up for consideration at the request of the learned counsel for the you're for the appellant.
Yes, Your Lordship.
At the request of the learned counsel for the appellant, let this matter come up for consideration on give a date tomorrow.
Please, Your Lordships. I beg to mention item number 12, 13, 14, and 15. May it be taken up tomorrow?
If you're mentioning in 12, 13, 14, and 15,
11.
I think you have to mention in 11 also. Have you taken the consent of the council?
Yes. Yes.
Have you?
Yes. Tomorrow. Okay.
Tomorrow. As prayed for on behalf of this is appeal by the state, no?
Yes.
As prayed for on behalf of the respondents. Why don't you change the system of the petitioner standing here and the state standing there? Huh? That would be in tune with the system which is prevalent in the entire country. I'm not insisting for that, but I'm only saying that you can think about it. You know, every time your mind races in that direction. I look at here for petitioner. Anyway, that's your choice. You can change it. These are traditions which you can change.
Lordship, in principle seat, the petitioner appellant is under
Everywhere, not only in the principal seat, everywhere in the country, in all courts, and not only high courts, in every district court is the system. Anyway, that's for you to decide. You take a call sometimes. We are not insisting for it. All right, 11 to 15 at the request of the learned counsel for the respondents, let all these matters be listed on give a date tomorrow.
Please, Lordship, I beg to mention item number 17.
17.
Yes, Lordship,
Yes.
I pray this matter may be listed after the winter vacation.
Why?
Lordship, today I have overlooked the cost list and
But you have to inform the other side.
yes, I have
My
informed.
lord,
Yes.
I've been informed.
This is an admission, I think.
This is an admission matter, no?
Yes, Your Lordship, it should be in the hearing list because the procedure is complete.
Complete.
Yes, Your Lordship.
All right.
Paper book is also.
As I recall,
My lord.
at the request of the learned counsel for the state, let this appeal be listed under the heading hearing on give a date sometimes in late January.
17, 18.
18th. Late January could be third week also, depending on your calendar.
Yes, Lordship. Much better.
All right.
Yes, Your Lordship.
Please, my lord. First, I beg to mention item number 19 and 20, Lordship.
What happened?
Lordship, I have difficulty today. There's so it maybe kindly pass over.
All these matters would go for tomorrow. Doesn't matter. All right. You have some difficulty, we will accommodate you. At the request of the learned counsel for the state, let these matters be listed for consideration on tomorrow is 5th, no? To 4th. All right.
May I please, Your Lordships? May I please, Your Lordships? Lordships, I beg to mention item 4 and 5, Lordship. Here, the standing counsel, the PP for NI has some personal difficulties. He is unwell today.
Mention would be, Acha, you appear for the respondent.
No,
You
Lordship.
appear for the respondent.
No, Lordship.
Then
For the appellant, NIA.
for the appellant.
Yes, NI is the appellant here, Your Lordship. So the
No,
yes, Lordship.
you have already been granted bail.
Yes, my lord, I'm on bail, my lord.
All right, so
Application
there's
is-
no difficulty. Okay, at the request of land council for the NIA/appellant, let this matter come up for consideration. January end. Same matter, same order in item number 5.
Yes, Lordship.
All right.
And also item number 10.
10. So the list is over, no?
No, get it.
Item number 10. All right.
Obliged,
Separate orders in all these matters.
Obliged, Your Lordship.
But whenever a division bench, is convened, I think try not to take time.
Lordship.
All right. I can understand the festivity times, but then not always.
Lordship.
All right. Yes.
Obliged.
For orders, item number 1.
Service
It's already admitted.
Service is complete. It appears that the case is ripe for hearing with all the respondents served. Let this matter be listed under the appropriate heading on what would be the convenient date for all of you. Sometimes in January,
So,
give the date.
right after the opening
Right after the
of
all.
obliged.
For orders, item number 2.
May I plead your lordship?
Yes.
Lordship, I have the instruction from the principal counsel, Mr. N.K. Muri, to appear on his behalf. Lordship, he is in his native village and there is a network problem. So he has instructed me to appear on his behalf. And as per his instruction, he has instructed me to list the matter after winter vacation, your lordship.
That's all right. But then you tell your instructing counsel that maybe the writ petition would not be maintainable. There is a
Lordship.
provision for appeal. Now, situation is
Lordship.
different. The juvenile was, he was declared to be a measure. If you're questioning that decision,
Lordship.
the provision is there,
Lordship.
Juvenile Justice Care and Protection of Children Act. So this writ petition would not be maintainable as such. Tell him, because you're holding the brief for somebody, we are not passing any order today,
Lordship.
but inform him that he should be ready on this aspect of the matter. All right?
Lordship.
As
Lordship.
prayed for on behalf of the petitioner, let this matter come up for consideration on your date in late January.
Lordship.
For orders, item number 3.
Who appears for respondent number 6? You are appearing for whom? For a state?
For the state, your lordship.
Any idea about respondent number 6?
No, your lordship. I'm informed that it is, they are yet to make appearance, your lordship.
They are yet to make
Yes, your
appearance.
lordship.
Awaiting the appearance of respondent number 6. This matter is adjourned to so and so date.
Just like.
From the supplementary cost list for orders, item number 24.
Yes.
May I please, your lordship?
Yes, Mr. Smith.
This appeal is directed against the judgment and order dated 16/10/2025,
Yes.
passed in WPC number 128 of 2025. The matter relates to selection of the constables in the excise department.
Yes.
An advertisement was issued by the department
Yes.
where more than 10,000 candidates applied for the post.
Right.
And then the petitioners, they have appeared. Initially, as per the advertisement, it was only physical test and interview, that is Vivabus.
Yes.
Only two. Written was not included in the initial advertisement. But then there was a government notification which says that lays down a prescribed guideline that in all the uniforms services, they are exempted from the Nagaland State Selection Board. So departments were directed to constitute departmental recruitment board.
Yes.
And there in any departmental selection board,
Yes.
3 additional departments were included. That is the PNR, personal and administrative reforms.
Let us see the operative portion of the judgment impugned.
From paragraph 31 to 36. Of course, 29 is also important.
Paragraph.
From paragraph 31, Lord. more than 1 month in advance. And that was notified in the newspaper. And by including written text, nobody was unduly benefited, nor it has caused prejudice to anybody. Therefore, it is not hit by Article 14 of the Constitution, Lordships. Because if it is favoring some candidate by introduction of written, then yes, there is a point that rules of the game has affected. Changing the rules of the game in the midst of the exam has affected some candidates. And another aspect, Lordship, which is very vital to decide this case, the petitioners, they have appeared pursuant to the advertisement and they are challenging the advertisement.
That is
That was not brought either by the Council for the State nor the court has pointed out. Of course, the petitioners cannot bring that because it will go against them.
okay.
And having appeared in the examination,
We'll be issuing notice to the respondents.
Lordship, if the department is directed to proceed with the process of the
No,
selection,
we can't do that. That's we can't do that without hearing the other side. We'll give a short date
Lordship,
because this order, is in their favor. No, nothing can be done. I mean, if you have waited for this long, you can wait again.
and Lordship, one direction was issued that the department was directed to conduct the examination in terms of Memorandum 19/7/2016.
That's right. Let's see. We have heard Sri C.T. Jamir, learned senior advocate for the appellant state. This appeal is directed against the judgment and order dated 16/10/2025, passed by a learned single judge of this court in WPC number 128 of 2025, whereby the corrigendum dated 4/6/2025, introducing a written test in the excise constable's recruitment process, was quashed, and the appellant/state was directed to conduct recruitment strictly in terms of the original advertisement dated 7/4/2025 and memorandum dated 19/7/2016. The issue for consideration before this court is whether the inclusion of a written test through issuance of a corrigendum dated 4/6/2025, though taken out before the actual commencement of the assessment of the candidates, and perhaps in accordance with the provisions contained in the advertisement itself, permitting corrections, would be an impermissible alteration in the recruitment process, thereby changing the rule of the game midway. The contention of the appellants is that inclusion of a written test was necessitated because marking otherwise would have been difficult, and in accordance with the judgments of the Supreme Court, not more than 12.5% could be allocated for oral interviews. Since the original advertisement did not contain any provision for written examination, the same was included. But before was included, about which the candidates were notified quite in advance. The further contention of Mr. Jamir is that such inclusion of a written test is within the framework of the advertisement, which is essential for ensuring fairness, transparency, and adhering to the best practices in public employment. Stop. Great stress has been laid by Mr. Jameer on the fact that such inclusion was not without notice to all persons who had applied against the said advertisement. The
Bear with me, another aspect.
just a minute, let us complete it.
No problem.
By the impugned judgment,
16/10/2020.
the corrigendum dated 4/6/2025 has been quashed as noted above, along with the entire exercise is quashed, along with the physical test, which also in the estimation of the learned single judge was conducted in contravention of the memorandum dated 19/7/2016. The recruitment process was directed to be conducted strictly in terms of the advertisement dated 7/4/2025 and memorandum dated 19/7/2016 by putting the applicants only to physical test and the suitability test through viva voce as advertised. Mr. Jameer therefore contends that such decision remains suspect. Such decision is rendered suspect on the ground of unnecessary interference in the procedure adopted by the recruiting body for taking the recruitment process to a logical conclusion. In Tej Pratap Pathak and others versus Rajasthan High Court and others, 2025 2 SCC1, it has clearly been laid down that recruiting bodies, subject to the extant rules, may devise appropriate procedure for bringing the recruitment process to its logical end, provided the procedure so adopted is transparent, non-discriminatory, /non-arbitrary, and has a rational nexus to the object sought to be achieved. The corrigendum, next paragraph, the corrigendum, which has included written test, comes within the domain of the recruiting body and it passes the muster of the equality clause in Article 14 and 16 of the Constitution of India. There is a rational nexus for introducing written test, or else the entire process of recruitment would have been mired in controversy for the difficulty in assessing the suitability of a candidate only on the basis of physical test and interviews. In that case, more than 12.5% marks would have had to be allocated for oral interviews, which under the circumstances would have been impermissible. The rationale behind such decision was to successfully complete the recruitment exercise with fairness and probity. Stop. Let notices be issued to who would be the answering respondents?
Here the petitioners.
You have implemented them as party
Yes, yes.
Yes.
as response number so and so
Respondent number
1 to 16.
on steps being taken by the appellant state within a period of 1 week, both modes returnable on. You are keeping it in the second week of January because it's urgent. All right.
Court will reopen only from.
You can't do anything. We can't do anything about it. We can't do anything.
14th January is the reopening day.
The whole purpose will be different. Otherwise the process is complete. Now we are only contemplating whether we should allow you to continue with the process. In that case, it will be unfair to the others who have got an order in their favor.
Written test already completed, Lordship. Only Bebabu is left.
Again,
And petitioners have appeared.
Mr. Jamir has informed this court that pursuant to the corrigendum/addendum, written tests have already been conducted. Stop. In that case, we deem it appropriate to, in the meantime, permit the state to continue with the recruitment process, but making the entire result subject to the outcome of the writ petition, outcome of the appeal. The result of the candidate shall not be declared without the leave of the appellate court, without the leave of this court.
Lord. And IA is there seeking for stay suspension of the Indian order, but I think that will take care of.
We have couched it in a different way.
Much obliged, Lord.
For admission, item number 6.
Subject will. Yes,
Please, Your Lordships.
you have been convicted.
Yes, Your Lordship.
Under which sections? Under which sections have you been convicted?
Yes, Your Lord. I apologize, Your Lordship. 6.
The appellant stands
Under
convicted.
the section 3.
All right, that should come from you straight away.
My lord, yeah, Lord.
The appellant stands convicted under section so and so by judgment and order dated so and so, while judgment dated so and has been sentenced to undergo so and so by order dated so and so.
My lord.
First up, this appeal is admitted for hearing. Call for the trial court records. Let this case be listed for final hearing on first week of February.
My lord.
Are you pressing for bail?
Yes, Your Lordship, I wanted to press for bail.
As a cut this is admitted for hearing. The learned counsel for the appellant applicant presses for grant of bail during the pendency of the appeal. First up, let's see the CRPC. Social, that report has to come from the state, no? What do the fault? Suppose not 389. Excellent. क्या लिखा है पूरा? Bail during the pendency of this appeal. In accordance with the proviso to section 389 of the Code of Criminal Procedure, the state is granted time to file a show cause in writing against such
Your Lordship, they have already filed.
against such.
Yes, a written objection.
You have already filed your written objection.
My lord.
First up, the written objection, the written objection has already been filed, which on behalf of the state. written objection on behalf of the state has already been.
I'm waiting for response number 2 to be informed.
Two is the.
All right, so you argue then. You argue then everything is complete. We will hear. Are you on the question of suspension of sentence?
If I have filed any objection to the.
I mean, do you want to file or you can argue orally?
If I may be allowed sometime to.
We will definitely give you chance, but then you'll have to ask for it, no? Your appearance is good enough for us. Like, so and so appears for respondent number 2, who wishes to file the response to this to the application seeking, to the prayer seeking bail during the pendency of the appeal. Let such a response affidavit, let such a show. What do you call it? Objection petition. Let such an objection petition be filed by the next date. Re-notify on so and so date.
Lordship.
February 1st week.
For admission, item number 7.
I think this posthumous regularization, the all set of matters are coming tomorrow, 11 with 15. I think it's the same matter.
Similar.
Similar. So we'll decide it tomorrow.
Right.
Let this matter also come up on so and so date, that is tomorrow, along with the batch of cases, the lead case being WA 8 of 2023.
For admission, item number 8.
An appointment.
Yes.
Lordship, here, this is a matter pertaining to land ownership that is prevalent in Nagaland. Therefore, appointments are privileged for the land owners. Now, here I have only 2 issues here, Lordship. The respondent have admitted that he is not a landowner. That is admitted before this honorable court. Now, the impugned order.
No, I didn't follow. Respondents have admitted of what?
He's not landowner.
That they are not the landowners.
No.
Yes.
I am the landowner.
You are the landowner.
Yes, they have admitted that we are not landowners. Now,
He denies.
no.
He says that he has not admitted it. Anyway, we'll see the records. Yes, then.
Yes, Lordship. Lordship, I'm challenging the 26, paragraph 14,
You're challenging what?
the impugned order,
Paragraph?
paragraph 14. That is 26.
We'll
page
find it at
26.
which page?
26, Lordship.
149. Paragraph 24. 14.
26, page 26, paragraph 14.
Paragraph 14. What
Yeah,
does it say?
14.
You have come to the penultimate paragraph. Now that's not the reasoning there, no? Let's see. Let's read that paragraph.
14.
Yes. Yes. Paragraph.
It says, Lordship, taking into account the fact that 2 persons have already been appointed on the basis of land ownership, this court is of the opinion that the petitioner has no right to claim appointment on land ownership basis, more particularly in view of clause 3C of the notification dated 5/3/2018. The authorities relied upon by the petitioner are evidently not relevant to the instant writ petition. Under these facts and circumstances, there is no merit in the instant writ petition and the same stand dismissed. Now, Lordship, I am challenging this order because
Who are these 2 persons?
2 persons.
One is Otoka Aye.
He is the respondent number 5,
Yes.
appointed through backdoor. In my land owner post. Now, Lordship, what has happened is, Lordship, the executive engineer office is the IME clan. There are 2 clans. That is IME clan, that is the respondent number 5 clan, though he is not a landowner. There is a clan system here in practice. And Lordship, what has happened is the Ayami clan are the landowners of Executive Engineer Atoi's office. Then in between them, there are about 2 kilometers between the two offices. We are the landowners.
Just a minute, Ms. Zimomi,
Yes.
this is the problem. The problem with the judgment impugned in the present petition, in the present appeal,
Lordship.
these issues cannot be decided in a writ petition. It ought not to have been decided. In fact, you should have been shut out in the first instance. That this is the claim, and therefore there will be a rival claim to be adjudicated in a writ petition is unheard of. Or you had to go before the appropriate authority to say that you are the landowner and not them. And then perhaps the writ court could have dealt with it. But nonetheless, the impugned judgment says that 2 persons have already been appointed on the basis of land ownership. Now, one is being represented by him. Who is the other?
Your Lordship,
No,
let
no,
me-
they are not the
Two
two
other
landowners. They are, the judgment says that we have already got 2 landowner appointment. That's why I'm not eligible.
That's what I'm saying, no?
Yes.
So
but
who are those 2 persons?
now, Lordship, that's why, Lordship.
Your
I
Lordship,
will
I
satisfy
find
my-
your-
As per number 5 and 6, the other 2 persons appointed.
Your Lordship, they are not in this case. But the state had filed the report on the basis of.
But why do we seek a report unless you challenge, unless you implead them?
No, Lordship. Just a little
May I, my Lordship, very
patience
quickly?
for my Lordships.
She has a right to argue, no?
Your Lord.
Here, what is, my Lord, will kindly come to page 76.
Now you don't take us to any page. You tell us one thing. Now, if you want to succeed in this matter, what would you be required to do?
Lordship, there.
You would be required to question the correctness of the finding of the learned single judge that those 2 persons who have been appointed on class 4 post, they are not on the basis of those appointments are not on the basis of their having donated land or they're coming from a family which has donated the land.
There were 3
Oh,
persons.
Please, you have to wait for the court to complete.
Lordship.
So this is the only way in which you can challenge the judgment of the single judge. Right?
Lordship.
Or you can say in a different way that the court should not have held that. The court should have avoided deciding this issue because this is an issue which has to be decided on facts and facts which are disputed. And if there is no dispute, then perhaps you have a easy cakewalk. Otherwise, now I'm coming to the last part of it. Otherwise, your appeal would only be maintainable if you implead those 2 appointed persons. Here,
Lordship, just for clarity.
no, let me make it this very clear to you. Suppose you have to be, you make out a case that you need to be appointed on class 4 post on the basis of donation of land to the government by a family. In that case, the 2 persons will have to be chucked out.
No.
No.
Just one explanation, Lordship.
Yes.
3 persons donated land for establishment of subdivisional office.
All right.
Atoiza.
All right.
So the government themselves have submitted this map 76, page 76. The 3 persons, individual land for establishment of Atoiza subdivisional office. Am I clear, Lordship?
No. No. You have detract yourself. You're going on a different track altogether. We have told you what we want from you. Let's hear from the state. Now, what is the status you're appearing? Can I have your name, please?
Lordship, we are going by the standard policy of the state.
No, can I have your name, please? Your name. So the council's name.
Senior government advocate.
You are government advocate, senior government advocate. Now you tell us, these 2 persons whom you have appointed on class 4 post in the office of the executive engineer,
Lordship,
were those persons appointed on the basis of their families having donated lands or not?
yes.
And she claims to be a person belonging to the same family which has donated land?
Three,
Three families.
amongst the three.
No.
Government has already
Three
admitted,
plus
Lordship.
children.
Now, page 70, page 75,
76,
76.
76.
What do you have to say to this page 76?
My lord, please appreciate page 74. This is the inquiry report.
Page 74.
When the writ petition was proceeding, a direction was issued by this honorable court to make an inquiry,
Yes.
and the inquiry was done. So, page 74, your lordship, the report is furnished by the extra assistant commissioner, who is of the additional deputy commissioner and additional district magistrate at Nagaland. Lordship, may kindly come to 8 meters discussed.
One.
Para 2, 1.
Yes.
One.
Admission by Sri V. Koto A. Sumi on his false
Petition.
claims.
Appellant.
Appellant.
Yes.
This is the appellant. This is the appellant, and this appeal. Sri V. Koto Swami, the petitioner and WBC number 6, 2024, openly admitted during the meeting that his earlier claim of being landowner of the land, on which the executive engineer's office is situated, as stated in various documents, was false.
How do you say that? How do you say that? Inquiry merely by saying that the claim of particular appellant or petitioner is false, you have to substantiate it with reasons.
No, Lordship, this is an inquiry report.
No, inquiry is based on what documents?
Statement.
It's a mere statement unless it is supported by documents. Suppose we say that Mr. Moa does not have a law degree. Suppose we say. Now, it has to be proved, no. Merely saying this will not do. So this circle officer or whichever is the person who is in charge of giving a certificate, he must confirm to the fact or he must show some document. I don't know which document do you see for testing the ownership of the land, but it has to be found out from there. So this inquiry report must be based on certain documents. Which is that document? Which is that document? Because you see just a minute, one at a time. We are not concluding the petition without hearing all the parties. Correct? All right. What is it?
Paragraph 3.
Yes.
There are 2 layers.
Read paragraph 3 then.
Appointment of Sri Heneto X and Srimati Pokatoli Sumi. It was noted that Sri Heneto X, son of Jobi and Srimati Pokatoli Sumi, daughter-in-law of Nitovi Dopi, has been appointed based on land donations by Sri Kotoi family for the establishment of subdivisional officer PWD Road and Bridges to the subdivision. These appointments were made in accordance with prior recommendation by the family contradicting the petitioner's current clients.
No, that doesn't answer, Mr. Counsel. What is your name? What is your name?
My name is Joshua. And page 76 is also a continuation. with
Mr. Joshua, that's right, Mr. Joshua. This does not tell us, this does not quench our query. It says that 2 persons have been appointed, that's good. But the claim of Jimomi is incorrect, that has to be established. No. See, there could be 3, landowners. There could be 3 families which may have donated land.
Yes.
Parcel of which may have been used for construction of the building. Correct?
Well,
So every landowner will, one member from each family which has donated the land will have a right to be appointed. Of course, this is typically only for this state of Nagaland. Nowhere does it happen. It's not a correct way of appointing, but then you have your own rules. So therefore, we are going by those rules. If 3 families have donated land, forget about donation. If on the land of 3 families, if a building has been constructed. So two have been given appointment, the third also will have to be given. No, that is what she is saying.
Lordship, as far as the settlement position before this honorable court is concerned, this is not the first land matter which is before this honorable court. If it is a composite land, single land, even if there are 10 families, this honorable court in catching out decisions on land matters have decided that one person appointed, now that fulfills the 5/3/2018 notification for a single land, even if there are 10 landowners, one appointment suffices.
Okay.
Yes, Your Lordship, that is now the set.
So your appointment was made before her claim.
My appointment, Your Lordship, there are two lands, which I wanted to clarify before Your Lordships. The land which has been donated by the family of the appellant is the land where the SDO office, subdivisional office was earlier situated. And the other office is the office of the executive engineer. And the executive engineer's office is where there are different family of landowners who donated that land. And the appointment was made in the office of the executive engineer, not the SDO. That is why the statement was taken and the same is reflected in the report. As far as the executive engineer's office is concerned, Your Lordship, I was recommended by the landowners to be appointed.
There is no recommendation.
Just a minute.
In other words, my lords will appreciate this point that they have given up their right to recommend me.
No, we are not getting into that
No.
controversy.
No.
Now, the state will, Mr. Moa will tell us.
Hello.
Now, these two appointments have been made because of the land used by the land used in construction of executive engineer's office. Now, SDO's office, I think her land has been used.
Yes.
So therefore, her claim is independent of their claim.
Yes.
That is what you want to say.
Not
Her claim-
exactly.
Her claim is independent of the claim of respondents. You are again shaking your head in denial. We are not disturbing you. We are not disturbing you. Now, would it be an incorrect position to say that you two have been appointed because of the land consumed by the executive engineer office?
SDO.
Executive engineer.
SDO.
And her land SDO.
I am.
So therefore, she has an independent right without disturbing your right. Where do you have problem here?
Sorry,
Lordship.
Lord. Now they're trying to play in the
Executive.
vacancy of the executive.
No, that they can't.
No, I am not. I am not. Lordship,
No.
let me clarify. If my lord will kindly, yes, this is interesting in fact. Here, what I'm trying to place before this honorable court is two person, they are claiming that two person have been appointed under executive engineer, under
You
subdivisional
don't have any quarrel with them.
of office. I have, because he has been appointed in my landowner grade 4 post. I'll satisfy my lordship.
That is paragraph.
I'll satisfy my lordship. This is a little bit of
You see the name, see his photo.
She is, what is her name? She is
V
Gauhati.
Okay, now we come to paragraph 3. His photo family recommended Nito Vichopi.
Nitovich Chopi.
yes.
Okay, his photo family recommend. So now she claims that she is entitled for this photo family.
Then
Ah,
this is not
so-
the land. This is not the land. This has not been used.
Only one issue, only two issue, lordship,
So who will decide it here?
just one issue. Lordship, the one there,
Just a minute. He claims that Khotoi family recommended his client's name, not your name.
no,
No.
Ayemi,
Ah.
there are two clans. Ayemi clan are the landowners of executive engineer
Ah.
office. That is it. Chopi clan, Chopi clan are the landowners of
SDO.
subdivisional office. Present appellant. In between, there are 2 kilometers in between. So there is no dispute. Now, what has happened is vacancy arose under the subdivisional office. Vacancy arose. Then in that vacancy, I was after for appointment, first appointment, lordship. 3 person donated the land. He was appointed in my Chopimi clan under subdivisional office. That is the factual position here. Now, they claim that they were appointed under sub-divisional office, but if my lord will kindly peruse the certificate that was issued, who served under the sub-divisional office, 2 persons where they serve under the sub-divisional office has given a statement that the post fell vacant under the post fell vacant under.
I think Mr. Moa, only you can resolve the difficult situation. You tell us whether these appointments were against the vacancy in SDO's office or in executive engineer's office.
No, Lordship, see the factual position. They are trying to twist.
Ms. Jimomi, we are not deciding a suit.
Lordship,
If you entangle us in these factual, claims and counterclaims, we'll reject the petition. We'll say nothing can be done. The single judge wrongly held that you are not entitled. For your entitlement, you have to go before the civil court.
Or customary court.
Or customary court, whichever.
Lordship, I just want to humbly pray before this honorable court that 2 persons has been appointed. That is what they are saying. One Bokatoli Simi was not appointed under land ownership. That is what I'm trying
For
to.
they are asking Mr. Government Advocate, you please tell us these 2 persons who have been appointed on the landowner's quota, have they been appointed? Please hear the question correctly. Have they been appointed against the vacancy which had arisen in executive engineer's office or SDO's office? Where is that statement? Make that statement and then we are done with it. We conclude it.
With something, some.
Lordship,
Where is that statement in your inquiry report? Now, don't detain us like this in factual squabbles.
Lordship, I'll just 1 minute. I'll just take your lordship to the standing policy of the state in regard to appointment.
That standing policy we shall consider later.
Yes.
We shall consider that later. You tell us whether the appointment of Mr. Joshua's client or and another go.
My friend will be in a position.
No. You have to say that. He will only claim that he has been appointed against the vacancy of executive engineer.
They are claiming that, but it's not.
You have to tell us.
Lordship,
Why can't you find out and tell us that these appointments were against the vacancy in which office? I think that will clinch the issue. We are not going to enter into all this clan business.
Yes.
Lordship, the factual position, my friend will be able to.
Why are you passing the buck to him? You're the government advocate, no? You're the government advocate. You have to find out the records. You have to tell us. For your Joshua, Mr. Joshua will not say anything which will destabilize his client. So therefore, we have to rely on the records of the state. Why can't you why are you shy in coming up with the correct statement?
How many people said appointed in executive officer against landowner and in SDO? And who are they? That's all.
That's right.
Lordship.
You don't have to go beyond. You just say these 2 persons have been appointed against the vacancy which had arisen in the office of executive engineer. We will deal with it. Or in the vacancy in the office of SDO. That will only make or destroy her claim. He has still not followed. Mr. Moa, you have not followed.
You have that instruction.
Dividing also 2 lines of issue which my very friend can ask from the government. Not here. In fact, the truth which my learned friend for the appellant also knows that SDO office is no more functional. In fact, the whole office has been shifted and is now functioning within the campus of the executive engineer's office. And the 2 appointments which.
That statement we will not accept from you.
Yes, Lord.
That statement has to come from him.
Yes, my Lord.
We saw the learned advocate general here. Where is he? You seem to be reluctant. Mr. Moa, you seem to be reluctant to give us correct information.
I'm sorry, Lordship, this case was been handled by my.
That's all right. So you can say that. But if you show your reservation, then we will ask the learned advocate general to look into the matter. Mr. Moa, that's not the way we deal with lawyers. When we are asking you to do something, you're not saying yes or no. That's not the way, no? That's not the way. the time of the court is precious. And it's your time, it's your public time.
Lordship.
And you're taking a stand where you don't want to say anything, you don't want to concede to anything. It's very difficult. Mr. Balgopal, we will request you to look into the matter. Now, Jimomi wants an appointment against a landholder's quota. Her appointment has been, her claim has been frustrated on the ground that against that quota, 2 persons have already been appointed. Therefore, she cannot be the third person to be appointed. These 2 persons say that no, there is some confusion. They belong to the same larger clan, but there are 3 parts. So land was donated by all the 3 wings, all the 3 parts of same big family. But then these appointments have to be made against the vacancies arising in the office which is located on that land. So Mr. Joshua says that his clients were appointed against a vacancy which arose in the office of the executive engineer.
I'm saying,
Just a minute. Executive engineer. She says that no, one of them have been appointed against a vacancy which arose in the office of the SDO.
exactly.
And the SDO's office is located on the land which has been donated by her family.
Yes.
So we just wanted a clarification from the government. These 2 appointments are against which vacancy? He says he can better say. Would the government will be in a better position to say that, or the private party?
We'll also find out.
You have to find out and tell us. He was taking a very hardline kind of a stance. He's not ready to look into the facts. He says, no, I will not do anything. That's the, Mr. Moa, an instruction for advisory from the bench. That's not the way you deal with the bench. When the court is asking you to find out, the best thing that you can do is to take time and say that you will look at the records and see that. We would not have troubled the.
I apologize for.
We would not have troubled learned advocate general. That's all right. We don't take it seriously, but see, this is not the way a government advocate has to conduct himself. You must say that. That you don't know, you will check up. We are not asking you to give the details now. You can always find out. We are not here deciding a civil suit, are we? So therefore, if the facts are not disputed, we will decide. We will say that the single judge was wrong. Why do you have to take time unnecessarily? You should have said it first. Mr. Balgopal, please, you have followed. You let him know. Take down. The claim of the appellant, as a here. There is an appeal against the judgment passed by a learned single judge dated so and so in WPC number so and so. First, by the impugned judgment, the claim of the appellant for being appointed on a class 4 post in the landowner's quota has been rejected primarily on the ground that against such quota, 2 persons have already been appointed. One of whom is represented here. Stop. One of such persons appointed against that quota is being represented by Mr. Joshua, who submits that the 2 appointments made in the landholder's quota was against the vacancy which occurred in the office of the executive engineer, PWD. PWD.
Yes.
Executive engineer, PWD.
Auto is division. Auto is division.
Which division? PWD of so and so division. First up. The learned counsel for the appellant, however, contends that this is not factually correct. And the appointments, one of the appointments have been made against the vacancy arising in the office of the SDO, which office is located on the land donated by the family of the appellant. First up. Controverting such a statement, Mr. Joshua Learned Counsel for respondent number 5 has submitted that the office of the SDO has now been relocated and every branch of that department is now located on the land donated by the family of the two appointees.
No.
Respond number 5. Only respond number 5. Or on the respond number 5. First up, they state the next paragraph. The learned senior government advocate, however, is non-committal in explaining the actual state of affairs, especially as to the appointments have been made against which vacancy. First up, we would therefore request the learned advocate general to look into the matter and inform this court by the next date as to the fact about the appointments against which vacancy. Appointments having been made against which vacancy. First up, let this matter come up for consideration on so and so date. 15 days. We have not, we will not say that unnecessarily, Mr. Mua. Huh? See, but you must be careful. The learned senior government advocate shall look into the records of the case and shall update the court on the next date about the factual position. All right. Oh, so you should have said that. Therefore, we have struck off all such things which could have been read against you. All right. Yes.
Just before this honorable.
Now let that affidavit come.
For admission, item number 9.
9. Yes.
Number 5, influence company.
Yes.
In terms of the order dated 12/11/2025, I have filed a affidavit for indicating steps taken for the procurement of no certificate today morning itself.
You have filed it in the morning. I think have you given a copy in advance to her?
Lordships have just used the copy this morning, just this morning.
Take down. The Land Council for the respond number 5 submits that the required affidavit has been filed only today in the morning, but only after serving a copy of the same to the counsel for the petitioner. The Land Council for the petitioner submits that she has received the copy of the affidavit referred to above only today in the morning, and that she'll require some time to go through the same before addressing this court. Let this matter come up for consideration on any date. Tomorrow, can you do that tomorrow?
Because here's the question of
Lordship, there is another issue, Lordship. What happened, Lordship?
Another issue, we will first have that issue.
We need some time, Lordship, because suddenly on 27th of November.
That means you're hiding against something.
Lordship, Lordship, the main issue is if we have been directed.
Otherwise, had you made payments, you'd have made necessary, compliances. Perhaps you would have wanted the matter to be heard tomorrow.
Also filed a notice certificate of many hospitals, Lordship. What happened?
Many we are not concerned. We are concerned with all.
Lordship, what happened on suddenly on 27 November?
Anyway, let it come on last day, which is the second last working day.
The last working day is 12.
12.
I think 11th of November, 11th of December.
Lordship, 10th, I am in fixed matter in Gauhati High Court.
You would be coming to Gauhati to argue the case, or you would be joining online. You would be joining online.
Lordship, I will physically come.
You can join online here.
Okay.
10th or 11th, whichever is 11th.
For hearing, item numbers 21 and 22.
Yes.
May I please lordship?
Yes.
This appeal is directed against judgment dated 1/8/2025,
Yes.
passed in with petition 239 of 2024, by which the general single judge was pleased to dismiss the writ appeal. The writ petition on the ground that petitioner does not have the locus to challenge the policy decision.
And what had happened?
Now, the policy decision, your lordship, which is under challenge in the writ petition, is a cabinet decision dated 6/8/2024 to regularize the service of 98 medical officers who have rendered service during COVID-19 pandemic, your lordship. Now, the ground on which the appellant has challenged the cabinet petition, your lordship.
First of all, tell us, you are Mr.
I'm TB Jamir.
Mr. TB Jamil. The person who appeared, the president of the Bar Association is CT Jamil.
City,
You're TB Jamil.
TB Jamir.
All right, all right. Yes, whom do you represent?
The appellants, your
No, no, who are they?
Now, the appellants, they all are MBBS graduate, your lordship.
MBBS graduates.
Graduate. And as per the service rule, which is Nagaland Health Service Rules to the.
No, one at a time. You are MBBS graduates.
Yeah.
You challenged which decision of the government?
The cabinet decision dated 6/8/2024
What does it say?
to regularize the service of 98 medical officers who have rendered service during COVID-19 pandemic.
And what was the reason for your challenge?
My reason for the challenge is that
They would have filled up the vacancy and you would have been, you would be rendered jobless.
job. And
No, you had never entered the job, no.
I've never, but I am eligible as per the service.
That's right.
And your lordship, that policy decision, your lordship, is violative of the statutory provision. Because as per the service rule, the post of medical officer is to be filled up by way of direct recruitment to the Nagaland Public Service Commission, your lordship. And that, therefore, your lordship, it is violative of Article 14 and 16 of the Constitution of India. And also, the policy decision, your lordship, it is against the settled principle of law as laid down by the Honorable Appeals Court in the case of MRTV, your lordship. So that was the ground for challenging.
So these 98 persons who were appointed during COVID times,
Lordship,
this appointment was temporary,
they were temporary.
no advertisement.
No, it was advertised, but that not through commission, your lordship.
It was advertised, not through commission,
Not through.
but special recruitment drive,
Correct.
which happens during these times of distress.
Correct.
Now,
And
theref-
in the advertisement itself, it has been specially stated that they will have no, it is temporary, appointment is temporary, and they will have no right to regularization.
that's all right, yes. And they work for how many years? This decision to regularize comes when?
That,
After how many years of their serving the department?
your lordship, they were appointed in the year 2020, and the cabinet decision was taken in the year 2024.
No, they were appointed in 2020 or 21?
2020.
2020. And this,
They were appointed on 12/11.
that's right, the year would be sufficient. And they have been regularized when?
The decision to regularize. cabinet.
Decision.
That is on 6/8/2024, that decision was.
Yes. Yes. So you say that the government would have done better by advertising such posts.
Your lordship, as per
And
the-
if they could be given weightage of marks, perhaps you would not have questioned.
Yes, some preference, in fact, a recommendation is there from the Ministry of Health and Government of India to give preference to them, your lordship. Preference in matter related to recruitment.
And age relaxation also.
Not regular, yes, your lordship. That is.
But then, in this matter, this is not a public interest matter. It may have, the fallout would be in public interest, but yours is a vested interest.
That's it, but then, your lordship, as per the service.
So therefore, we are only testing it. We are not denying what you're saying. We are only trying to test on legal proposition.
Lord.
The single judge says that your claim is bogus.
Yeah.
You have not yet entered the service. You're nothing.
I have no locus.
You have no locus. And perhaps the celebrated decision of Ayub Khan, which is quoted everywhere. Right.
And that relates to different issue, Lordship. Issues of caste certificate, verification.
We are aware.
Lordship.
We are aware. So you say that any appointment dehoors the rules is bad in the eyes of law. So we have Uma Devi is all right. If you say Uma Devi, Mr. Balgopal will talk about Jago and Dharamveer.
Participation.
So he has not appeared. Unless they come out with an advertisement, how will he participate? So
Since proposals of
you think that the state would do only with these 98 persons and they will not advertise for more posts?
In fact, Your Lordship, now,
No, we are asking you a different question in a different way. We are asking you that these are the only 98 posts where you will be eligible, or you would be eligible for some other posts also which will be advertised by the government.
Your Lordship, Nagaland is a very small state. In the past 10 years, Your Lordship, less than 100 posts were advertised. Less than 100. And this is not 1, 2 posts or 10, 20 posts, 98 posts of medical officer, Your Lordship. If they are regular, in fact, Your Lordship, not only our future, in fact, there's no future prospect for us for appointment, Your Lordship.
all these persons will have to be policed.
But how was this maintained? And then look at this. There is some interim order in your favor. Correct?
Not exactly, Your Lordship.
Yes.
In fact, the leadership.
The judgment has been stayed.
Yes.
How can a judgment be stayed? It has to be decided.
No, it has not been stayed, Your Lordship. It has not been. Your Lordship, may I see the order dated 3.
Yeah, we accordingly passed the following interim directions. The cabinet decision dated so and so is stayed. So for all practical purposes, the judgment of the single judge has been stayed. No steps for regularization shall be taken.
Yes.
We have not given from participation in on
They say that we have very limited posts, but can that be a reason for the courts to interfere? And then should this appeal have been heard without impeding those 98 persons? It goes against them. Or you are being represented?
Yes.
All right. You're all there. What you're saying is correct. Morally correct. But legally, whether we can say that.
In fact, Your Lordship, even if at all any relaxation has to be paid, Your Lordship.
No, that's right.
There has to be a provision.
You have said, therefore we said that your submission is that the government would have done better if they had advertised with some preference to them.
Lordship.
Agreed. But then the government has taken a decision to regularize, and they are not interlopers. They are not backdoor appointment. Their appointments were against an advertisement, though of course no commission was not consulted. And they have the rules.
Yes. And even, Your Lordship, the advertisement, even the appointment in the both in advertisement and the appointment.
This challenge coming from them is not acceptable. It would have come with respect to regularity after commencement of the regulation with a challenge.
Your case is that
But no, I understand that case because they will just, these regularized persons will fill up the places and they will not have any opportunity. Any future. Suppose if we extend this logic of yours, we are on another question. Please don't, Mr. Jamir, please don't take us amiss. What you're saying has some bearing. It has some force. But we are extending it further. Suppose we are thinking of a hypothetical situation where a body of student would say that the first batch, which was made eligible because of age for writing the examination, that batch is useless. So if they fill up the entire post, then what will we do when we will come of the age?
No, I am not casting any expression.
We have followed that. So therefore, if the posts are filled by regular appointees can you question that regularization once they were appointed on temporary basis, they served well. I mean, we are only looking at their point of view also. Whether we as judges could get into that decision making of the government when it is not per se illegal.
In matter relating to judicial review.
See, let us see Jago. Jago says that please don't talk about anything. If you take work from people against sanctioned vacant posts, then financial stringency or whatever, you please regularize them. That's bad. So during COVID times, we are testing it from the point of view of Jago and Dharam.
But that was not a statutory rule, sir.
That's right. That's right. Principle we are talking. And or Sripal, there are 3 cases which are of the same yona. So these persons, suppose they continue in the service, the government would have done better. We have encapsulated your argument in this. The government would have done better. Yes, Mr. Balgopal.
This was a warlike situation.
So we are not on that. Your appointment, you're giving temporary appointment to these 98 people, absolutely fine.
Please.
We are not questioning it. We are not questioning it. He's questioning that you don't do this. Nagaland is a small state with no employment opportunities, and we are medical graduates. Now let them be permitted to compete with these people with age on their side, experience on their side, and weightage of marks. But they can't be rendered completely jobless with no opportunity in future. That's the only ground. And we are rather suspicious about courts entering into this field.
But in the first place, this appointment was specific only for during the period of pandemic. What happened was many of the doctors would not come forward who were eligible to be appointed. They didn't only because of COVID. Some of these persons who are before your lordships, they were actually the COVID warriors facing the enemy directly. They were handling all these cases. So policy decision came from the government of India. I refer to that. In that, they said, even you appoint young people, whomever you get, you appoint. If they put in 100 days of service in COVID, appoint them. They have not worked one day. They were not even doctors. He's hiding his status. He
he's been very upfront. He says that we are only medical graduates. We never applied.
No, he was not medical graduate at that time when they were appointed. They were not. They were all students.
No, when they were appointed, of course they were students.
Yes.
Now they are graduates.
Now
and this is that why are you regularizing them?
Please, as far as that appointment was concerned, we went through a particular process. All the activities were done. Many cabinet policy decisions were taken. And the first decision is at page 171. I'll just draw your notes. Notice got this one?
Yes.
The first one is at page 169 for minutes of the meeting, where in the first paragraph, page
Yes.
169.
171 or 169?
169 first, I'm sorry. A high-power committee with the following competency shall be constituted to decide on policies relating to COVID-19, including supervision state orders. So there was a discussion at that time how to meet the pandemic. So the policy decision was initiated here. And later, in the subsequent page at 173, what you could see, the undersigned is that to give it an extract of minutes of the meeting of 11th June 2020. Kindly see page 172. Oh, yeah, that's right. So this is also regarding the appointment, they decided in this meeting that we should go in for recruitment. And the details of recruitment are there on page 174. Regularly they'll be having cabinet meetings. Kindly see 174A. Lord, have got that, fellow?
174?
174A. All the newly created posts should be filled up within a month's notice with proper advertisement. While filling up the post, the weightage should be given to marks obtained by the candidate in a qualifying degree. The interview shall include independent experts. The department should clearly indicate that these appointments will be temporary and regular recruitment shall be conducted through special NPSC. Now,
No, just a minute, Mr. Balgopal. Now, you just read all the newly created posts would be filled up by a Health and Family Welfare Department within a month's time with proper advertisement, correct?
We have done that.
While filling up the posts, due weightage should be given to the marks obtained by candidates in qualifying degree of. Yeah, no, that's something. What is the interview panel?
175 based on.
That's right. उसमें कहीं कोई दिक्कत नहीं है. They were created for the purpose and they have been regularized. These were temporary posts. That is their only contention. Page 171, they have created such posts. Correct.
all are sanctioned posts, my lord. Sanctioned posts. Then, my lord.
It's against a sanctioned post.
After going through all the procedures, your lordship would see at B or the same page 174, the department should clearly indicate these appointments will be temporary and regular recruitment shall be conducted through special NPSC recruitment drive.
What is NPSC?
Nagaland Public Service.
So therefore herein lies the
They're
fault
very
line.
important, definitely important.
This is the flashpoint.
Yes, I'll solve that out. I'll at least assist you in understanding.
Yes.
So it is not that we hid this point anywhere. Even in the appointment letters issued, we said your regularization will be subject to NPSC. So
Now your fresh recruitment.
very, very clear. We didn't. It was not like Madevi coming through the back door.
No, right.
Nobody was willing to come through any door, front, side, or back. Only these people came forward. Then, my lord, in all fairness, after various policy decisions, various discussions at different levels, we approached the NPS. Not that we didn't approach NPS.
Yes.
Now, finally see page 384. Is it 384?
384.
Please. My lord, report.
Just 1 second. Yes.
Inviting a reference, my lord, to
Yes.
the above cited subject and Health and Family Welfare Department notification dated 22nd November 2022. I'm directed to state special recruitment proposed by the department is not in accordance with the recruitment rules of the commission. You are therefore requested to kindly accord clearance to proceed with this recruitment process.
This is the Nagaland Public Service Commission.
They said that you are not in order. They would not recognize this procedure of this particular type of appointment. And my lord, as far as this is concerned, in the recruitment rules.
No, but this notification inviting a reference to the above subject. I am directed to state the special recruitment proposed by the department is not in accordance with the recruitment rules. So the commission doesn't sit tight over the matter. It doesn't approve of it.
Commission may not approve of it because they say that as far as this is concerned, they specifically say that I am directed to state special recruitment proposed by the department. There is no provision in the NPS with the NPSC which provides for one such contingency. This is whole of India.
This was for the first time that it had happened in the world.
And there's a government policy here. Government policy, my lord.
Now, did you respond to this?
Yes.
What is the
So
response?
we went back. We discussed the matter. Then we shortlisted some of the candidates who could be appointed in this. We again went back to NPSC. It's a pandemic, so many things were happening, we can't just do anything the way we want. Their reply is there on page 399. May I read it for you?
399, yes.
The commission has examined the file relating to conduct of special recruitment right for COVID authorities in respect of such and such and conduct the decision of the commission. Since the department has withdrawn the requisition for still posted in question on valid reason why such and such date in report, NPSC has no comment issue on the special recruitment level of COVID-19. Appointments to be conducted by Health and Welfare Department. And the whole exercise is within the prerogative of the department government. Now they throw the ball back on us. You have the prerogative. So it's not that we did not go to the NPSC. We went to the NPSC, we got a rebuff, we went through all the process. Again, we discussed the matter with the cabinet, came back, even to facilitate, these are the people we want to appoint. There they said, we will not look into it. You do it at your end. So it's not a case of where we avoided the NPSC. We were rebuffed, we went
No,
again.
no, this was under a special circumstance where you shortlisted people. So that process was only a confirmation of what you had done as an ad hoc arrangement. See, you just wanted a Public Service Commission's approval because you never asked the commission for a general recruitment drive, a special recruitment drive.
Well, the situation is like this. We went in for special recruitment. What was the situation?
The situation we understand.
And nobody is challenging that day, the way we were appointed is wrong. That's not the question.
No, that's.
In fact, the government of India said
They in fact would not fail in the first instance if they challenge that appointment. That justification you had. Excuse me, Khan. Ask him to switch off that. It has become very warm. उसको ऑफ करो या इसको हटा दो
kindly see, my lord. Page 331.
Yes.
This is the government of India. We went ahead with this policy only after government of India had issued instructions to all the states to go ahead with this type of appointments. In view of the need for increasing the availability of trained human resources to tackle the COVID-19 pandemic situation, following guidelines are being issued in consultation with the National Medical Council in India. So here, in the first paragraph, I only read 2, 3 things. Considering the current situation, eligibility come entrance is being postponed.
Now these appellants must be in final year. They must be final year PG students.
No, my lord. These people were not doctors. We were all qualified doctors. They didn't have a locus to appoint, to get appointed. As soon as they came out that this is not, they were, as the Supreme Court says, in the embryonic stage. They were not too much of an embryonic stage. So they were not in existence at that time. They were not eligible to apply for this post. If they are not eligible to apply for this post, then they have no right to file this petition. That was a very serious decision of the court, which we will point out to your lordships. They had no locus. They just thought that, okay, now we have gotten here, let us now trek and make a dispute. And these people have to be awarded. They faced the COVID. They didn't take any rest. They didn't take any leave. And the government was somehow trying to catch them so that they don't run away. And they did their work. Kindly see this, my lord. Next. The service of final year MBBS students in 3, my lord,
Yes.
can be utilized for providing services like teleconsultation, etc., etc., etc. So everyone they are trying to catch. Then they also say Where is my lord?
Read more courses. It will always be. No, that's not. I'm not taking with them. All of them. Mr. Balgopal, you just address us on their locus.
My lord,
Just address us on their locus.
from the
Locus.
On their locus.
Very good. No, as far as the locus is concerned,
Mr. Jamir, what is
I just got it.
passing in my mind is this, in our minds is this, that this could happen, that many eligible persons can go against the judgment of Dharmveer and Jago. Because those posts are regularized, of course, for a longer duration. But then if those posts were advertised with weightage to those people who had already been serving, it would have been, we are not taking it as some kind of a reward, but from your mouth, at their instance, whether it could be questioned.
Yeah.
No, therefore we have asked him to explain to us on locus. Sit down.
My lord, as far as their locus is concerned, as I pointed out to your lordships, they were students at that time.
No, let us give us, you give us some judgments on that. They were students, they are not eligible, they could have done nothing, they have just found out that these 98 posts are being regularized, so they have come.
I can point out the various judgments, my lord.
Yes,
I will give this to your lordships also.
yes.
Service matters where recruitment process was challenged by ineligible candidates. They were ineligible at that time. The Honorable Apex Court has consistently held High Court ought not to examine the case after it came to the finding petitions were not eligible to vote. So right from the beginning, they were nowhere.
This is a different kind of locus that they are claiming.
In another case, one of the Supreme Court has held in service during students, it is settled law. It is for the aggrieved persons, non-appointees to assign the legality of the offending action. Third party has no local standard to canvass the legality or correctness of the action. What all the series of judgments in this. They have neither the local standard nor are their rights infringed. They are trying to push it off like a PL, as your lordship has said. Then this Ashok Kumar Pandey, my lord, state of West Bengal. There the case says a time has come to weed out petitions which all these public interest, etc. They have discussed this at length. This is a very celebrated judgment. One thing we have to take into consideration is, my lord, after the order was passed, where you said you go ahead, we went ahead with the position. Question is, does the cabinet have the power? If we check up the rules of executive business, which I shall just place before your lordships. One minute, I have to take over. On Rule 14. Part 2, procedure of the cabinet. Rule 14.
Yes.
I'll read it. All cases referred to in the second schedule can, after consideration by the minister, be sent to the chief secretary with the view to obtaining orders of the chief minister for circulation of the case under Rule 15 for bringing it up for consideration of the meeting of the cabinet. This is Rule 15. The 15 is the chief minister may direct any case referred to in the second schedule may, instead of being brought for discussion, the meeting of the cabinet be circulated, etc. Now, they are talking about second schedule here. Second schedule is the last page which I've given to your lordships. Right at the bottom, 24 men. These are the powers as far as the cabinet is concerned. 24. Proposals involving any important alteration in the conditions of service of the members of any all India service or the state service or in the method of recruitment of service of post to which appointment is made by the government. So any important alteration. Now the cabinet is then empowered to look into this under Rule 24. Now finally see Rule 26, madam. Let's pat on the point. Proposal to act otherwise in accordance with the recommendation of the Public Service Commission. So we had to go ahead. And though they had initially rejected it, in pith and substance, they said that you go ahead. What do? We can't do anything else. We went, we showed our fairness, we went twice, they were also fair the second time, they said you go. So it is not a cabinet has exercised a power not vested with them. Power is vested with them, which is to be sparingly used, and this is one of the circumstances in which the cabinet had to exercise this particular portion. Then, my lord, we have gone through various policy decisions in this case, 20, 22, etc. We have filed all the policy decisions, we'll enumerate. None of these policy decisions are being challenged by them. None. They challenged only the later one, which was in August 24, when we were taking steps for the regularization when the government took the policy. So that is a continuation of the policy, and it is the law that if you challenge only the consequential policy, your lordship is aware of, and then you don't touch the earlier policies which are distinctly connected with this, then you can't challenge it.
No, but this is severable from the other cabinet decisions. This is a decision to regularize them, and this hits them hard, and therefore they have done it.
Yeah.
So that it is severable.
Does it not hit these people who worked for 4 years or 5 years continuously?
Therefore, they have very
under the assurance.
Therefore, they have very intelligently said that no, give them weightage. We have no difficulty.
My lord, as we went with those proposals before the NPSC. We didn't ask anything else. You decide. We are giving you. They rejected it. Is it the fault of the government? They rejected it. We didn't leave it. We went again. We went again to them. They said, okay, you do it at your end. So we did it at our end. And in doing this, we followed the procedure. Everybody, merit was looked into. Whatever the NPSC would do, we did it. Even at the time of...
That appointment is all right. We are not questioning that,
Mr.
Mr.
As far as the
This decision to regularize.
One of the conditions as per the policy is they should have spent 100 days working during the COVID period. They
To find out, that
yes.
these persons had
Yes,
really
we
worked
did,
for
we
100
did
years.
everything, and we even shortlisted the candidates even before doing all this.
So that decision already was taken.
We have done everything. We have to only execute that order. It is at that time they came to the court, saying that we are being discriminated. My lord, your lordship could see where is the question of discrimination. We are a class by themselves, by ourselves under Article 14 of the Constitution. We worked for 100 days during the COVID period, which they did not. So you cannot say there has been violation of Article 14.
Yes.
Therefore, my lord,
The separate class.
the other issue is, what is it actually? Is it 14, 16 or something? It's a clear case of Article 21 of the Constitution. The law is settled that if any statute or anything conflicts with 21 will prevail. Here are the doctors, as the cost of being casualties of Article 21 went ahead. For what purpose? So that the people of Nagaland who are here, who are suffering, they wanted to treat them. So actually the life and liberty of these citizens were in question. None of these people, whether they were in first year, second year or anything, none of them turned up. As soon as they pass, then you say this. And as far as the 100 days is concerned, that's very reasonable because we said, if you have not done 100 days, we won't do it. Those who have resigned and gone, we won't do it. There were various areas wherein they had to quit and go. So here, when we say that it is 100, suppose this was given that you don't have to do 100 days, we were assured, my lord, that they will be regularized. Otherwise, why would they put their thing in this whole exercise? Like a petitioner 111 and 55.
Okay.
Now, if you come to this,
782,020.
It's 726. No, page 408. Page 408.
Yeah, date will cover.
Page 64.
Yeah.
Next page. Next page.
Well, this is with respect to something else. Okay. And this at page 64, at page 405 of the brief, this 405.
please.
This is with respect to a different post, no? Not these 98.
So for this 98, no?
For this 98.
Yeah.
So after this again, there are 280 posts.
No.
Administrative, page 405, administrative approval to conduct written and viva voce of one-time dispensation of special recruitment drive of specific categories, 280 posts.
Yes. One-time dispensation, it is not forever. In that circumstance, we went it. And if the government makes a policy on one-time dispensation, my lord, how can they challenge it? Yes, all are medical persons. We had done all the groundwork. And it's a one-time.
I'm
24.
So after you appointed them under a special circumstance, then also you put them to some kind of. No, I don't think so.
They were working religiously, my lord. Continuously they were working. So the entire.
So after you have taken a decision to have us specially regularize them, you had a screening committee, written test and viva subsequently.
After this,
Yes. We never violated any steps. We didn't take the law into our hands.
Yes, not done.
We didn't do that.
okay. That is not going
The their case is that you cannot have this special. It should have been. But there are 280 posts, only 98 are appointed, regularized, proposed to be regularized.
That is inclusive of all the medical personnel.
They are under different fields. We are
They are
talking,
not questioning about others.
yeah, they are only
Nurses.
only doctors. We did the checks at each stage. There are many cases where they refuse to go to NPSC, not like that.
Business card. Yes, we can't entertain this appeal at your instance.
The next case is mine. I have challenged the cabinet decision as well as the selection, the handpicked list of 98. My clients, the appellants, have also served for 100 days or more during the COVID period. We have been left out. So if
Who are you?
my lord, we are doctors who have served during the COVID-19 period.
No, but why have you been left out?
We have been left out because we are on higher studies, Your Lordship. I have also filed an appeal.
But then you were on higher studies, but then you did not work for 100 days, no?
More than 100 days, Your Lordship. We have worked for more than 2 years.
But you were not continuing in service.
Lordship, we were not continuing in service, but we were not terminated. The condition of our appointment itself says that if we have served for 2 years, we'll be allowed to go for further studies. The memorandum, cabinet memorandum itself specifically states that preference will be given to doctors to go for further studies if they have served for 100 days or more. And we have served for more than 2 years. And my writ petition, our writ petition has been dismissed, and I have also filed an appeal, my lord.
They have resigned from service,
No, Your
gone
Lordship.
for higher education. After that, they've never been in service.
My lords will kindly appreciate that
You
we have not.
can't have the cake and eat it too.
No, your lordship, it is supposed to be a special recruitment drive, not
That's
in a
not
hand-picked
right.
manner, your
That's not
lordship.
right. That argument has been made. It's a special recruitment drive.
Yes, your
Now,
lordship.
therefore, there are three kinds of people. One who were recruited during emergency times. Emergency means pandemic times.
My lord.
And they serve to the best satisfaction
Yes, your
of
lordship.
the employer. And then some of them, after having worked for 2 years, 100 days, so to say, they resigned from the service and went for higher studies.
Your lordship.
They got preference.
Your lordship.
But the deciding point would be, the turning point would be whether you were in service at that time.
Your lordship.
Otherwise, anybody who has served
Yes.
during that period and did not continue will not be regularized. That is against the very policy of
Your
regularization.
lordship, it is not special recruitment drive, not for regularization. Your
That we
lordship.
have followed.
My lord.
We have followed that, sir.
My lord.
So therefore, you could have been the first person to question this because you were recruited against that drive. So you can question the decision of regularization that you have questioned, but then your objection also will meet the same fate for the reason that you chose to go. I mean, kudos to you that you served.
My lord.
But you chose to go, leave the organization. You did not continue. You were not on a study leave,
We applied for study leave,
but
your
you were
lordship.
not granted.
It was not granted,
So
your
therefore,
lordship,
you resigned.
against their own policy, your lordship.
That is, have you questioned that leave was not granted?
That,
No.
yes.
So when leave was not granted, you thought it to be more beneficial to quit the job and go for higher studies. Why stay in Nagaland only? Times were getting better. But how can you claim to be sailing on the same boat as him?
No, if he says special recruitment drive should be confined to only those 100 days, all whether in service or not in service.
This is not with us. We are not now testing the recruitment drive. Since the confirmation of Nagaland Public Service Commission, the appointments were made. No questions were asked. Now the questions are being asked only now when the decision has been taken by the cabinet to regularize them. And that's a policy decision. Suppose people coming to the court say that, well, we are working, we need to be regularized. The employer says that no, we have given them the temporary appointment. We have said that don't make any claim for regularization. Courts do not say that. Converse situation is also true. When the government decides to regularize, we can't question it because this appointment was not through backdoor. It was under a special circumstances. That is the argument.
My lord will kindly appreciate this.
Yes.
This special recruitment drive was meant for all healthcare workers, even in the private hospitals, COVID hospitals, not government employees who have served for 100 days. They are also supposed to be included in the special recruitment drive, my lord.
That's right. But here we are concerned with government hospitals.
Like lordship, if the private individuals
that
were
was-
not served,
that
how
was-
is the lordship?
See, look, you can't question that now. You were also appointed by the same mode. Correct?
Your lordship.
You were appointed by the same mode.
Yes, your lordship.
And now, once you were appointed by the same mode, you served for 2 years, you asked for a leave, study leave. Perhaps you were temporary employee, therefore their rules also would not say. I mean, even if there are rules, they rejected it. You did not question the rejection of the prayer for study leave. So you thought it better because better times had come. You needed to go for higher studies, for better avenues. You did that. So you have some case. We are not considering you to be completely aliens, but then you have served at some point of time. Suppose somebody serves an organization for say 100 days, and then he quits and goes. Can he come back again and say that, well, that was a wrong decision that I made. Please confirm me in service. Can you do that?
Lordship, if that conclusion is to be arrived at, then another
You, in fact, we will treat you as persons who left the field, leaving the government to fend for itself during difficult times.
Lordship,
You were concerned about your career. Please concern about that. I don't know. This was the So, matlab kya hai? Private hospital. See, the government had taken a decision, and the central ministry was asking all the private hospitals also to enlist even PG students for junior consultants. Because those were the times when they had to take medicines in accordance with WHO guidelines and
This was a protocol.
protocol. So those persons, even private hospitals are under some kind of a regulation not to employ quags and all that. But it was an urgent situation that those persons who were not employed in hospital. See, none of these no person is being regularized who was employed in private hospitals.
Nobody.
And then where is the question of making this?
Your Lordship, this conclusion will also overrule the judgment in another case, which was decided by the single bench of this own court in WPC number 166 of 2025.
We will not conflate those issues. We shall not conflate those issues.
In the case of the nurses, my lord, this own court, the single bench of this own court has decided that those who have served for 100 days, they should be included in the recruitment drive. My lord,
That's a different issue altogether. That's the first stage. These persons, the respondents number 19 to 101, they have crossed that stage.
There is under review, Your Lordship. This next case.
Okay.
The learned single judge order was passed after all this.
Yes.
Everything was taken into consideration. Yes. We are not dealing with those cases at all.
These are all government doctors.
respectfully, my lord, it will have some conflict because we have been left out in the 98 list. Now in the nurses case, my lord,
How do you say you have been left out? You are not there. You are not working with them.
In your case of artificial breaks, he volunteered. Wait.
Look at this. The government is a very smart employer. In fact, instead of being a good employer, model employer, they are smart employers.
Yeah.
They give you appointment for 1 year, then they don't confirm it after the expiry of 1 year. They will wait for 1 week, and then they will give you another appointment for another year, so that there is a break in the service, so that you don't come back to them and claim regularization.
and if my lord,
They are very intelligent that way. You can't hoodwink them by saying that no, we have worked for you, we will go somewhere else, we'll come back and you appoint me.
Your Lordship, the cabinet decision did not say that for in-service doctors. So though I challenged them and sought for mandamas, I asked for alteration, modification instead of asking for quashing it. But the letter dated 20th August 2024, which brought out a list of 98 doctors, which was not part of the cabinet decision, Your Lordship. So on that basis, I have filed an appeal because my writ petition was not allowed.
Sorry, you can give your 2-pager note in each of the appeals. But we are inclined to pronounce our judgment just now. But we'll keep it pending service. Please give your appearance slip in your matters and give a 2-pager note by tomorrow. We'll deal with it. Anybody else? Any other appeal pending? Any other? These are 2 appeals, no? 21 and 22. You are appearing in 22. Mr. Jamir, you are appearing in who? So how is he?
First case.
That's all right. So give your appearance slip. So you say you are with them.
Yes.
All right. So Mr. Takamasa and Mr. Jamir.
Yes.
Oh, same cause. Let's see. Both the appeals have been heard. We have heard so and so. Yes, Eliko. Both the appeals have been heard together, and
I think the nurses case may be heard because the item the issue is different. So that matter may be heard for a few minutes.
all right.
In that case,
We deal with the item number 21 only.
yes, item 21 only.
Item number 21. Yes, Eliko.
It's an oral judgment.
21 and 23.
Yes.
22 is the final.
Item number 21 and 23 करके लिखना. These 2 writ appeals have been heard together. We have heard so and so for the appellants and respondents. Take the appearance slip. Judgment reserved.
And your husband.
Item 18.
22 we'll hear again.
Yes.
I think if you can argue 22 now, we will hear you. Yes, then let's finish it off. Let us see 22.
Although the issue is, the only issue here is before the issue involved here is with regard to the nurses by the same cabinet decisions. Now in 2020, posts were created. The 2020 cabinet decision, the posts were created, and the rules were relaxed. Accordingly, if reasons were given, which lordship has used. Now, both the parties, the appellants and the regulations, we were all serving as nurses on contract basis in National Health Mission, Naga Hospital Authority, as well as in the private sector.
You do one thing, we will hear you on some other date. Otherwise the idea, it will get carried over in this case.
Okay, fine.
Yeah, let item number 22 be listed for consideration, further consideration next week.
Lordship on 10 next week.
On 10th next
Yes,
week,
sir.
all right. Otherwise, whatever we have heard in that will be carried over here.
Yes, I agree with that. And lordship, in item 21, we have to give visit submissions of
Pager.
lordship. By tomorrow or the other days?
As early as possible. By evening, we'll be happy. By
Lordship,
tomorrow, it will be okay.
By tomorrow, because day will be difficult.
Tomorrow.
For hearing, item number 18.
Criminal appeal. Yeah. Yes.
Lordship, if this matter can come up next week.
Why?
I have some difficulty to think also.
Why?
Since I have overlooked the matter, Lordship.
Overlook the matter, why? Anyway, as prayed for on behalf of the appellant, let this matter come up for consideration on next week. Next week. Hmm? This what? Oh, sorry, again, just a minute. You are the public prosecutor. This confusion lingers. Yes, we'll have to take his consent. What do you have to say? You're ready? Why do you worry for your friend? You say whether you're ready or not. You worry for your client, don't worry for him. You agree? Next week, all right. As prayed for on behalf of the respondent and agreed to by the counsel for the appellant, let this matter come up for consideration under the appropriate heading on so and so date. Next week. Chalo.
이전 그러면 court 3대 되고죠.
Excuse me. I'll give you the evidence. This one.
Item number 18. 18 will be next week now. So next week it will be on 10. Wednesday, yeah.
12, 25.
Yeah.
Then 22 is 10, 12.
22, yeah, 10, 12. Item number 22, nah? Fixed next week. So it will be on 10.
10, 12.
Hmm.
Sure.
Now.